Hey guys, so I've got a really brief video I just wanted to go through. Earlier today, I covered Lively's opposition to Wayfarer's renewed motion for judgment on the pleadings. The crux of Lively's argument, if you haven't seen the video already, I do recommend going and watching it. It will enrage you beautifully, but I'll be right there with you. But the crux of her argument is, well, I had a reasonable belief. I had a reasonable basis for believing that I could claim retaliation in California. And there are moments where it's a real stretch, actually. She tries to say, well, my California-based attorneys negotiated the ALA and CRA. Literally, that's one of the things she's like, oh, this is a nexus. No. Lively herself actually points out the difficulties of, like if you're working for a company which has got several offices around the country or even around the world, and you work for one full time, but you go and work for another, it's like, well, which law would apply? Yeah, so it's and then we had, oh my god, and then we had at the end, I had to read the declaration of Richard Marks, the expert witness for Lively, who also was Johnny Depp's former expert witness. He's an entertainment attorney, and he was, oh my god, he was literally trying to argue the point in there. He was sort of saying, well, the ALA, which has been dismissed it's unenforceable. It's been deemed unenforceable by Judge Lyman already. But he was like, well, we don't really, in this industry, it's quite common to not sign these things. And that really pissed me off. I completely lost my shit because no, you don't treat contracts like that at all, right? If you want to be, the benefit of the contract, you also have to, accept the burden of the contract, which means you sign it. And as much as, Richard Marks was like, oh, well, this is just a standard thing that we do, right? At the end of the day, Wayfarer did not want to do it like that at all. It was important for Lively to have signed the contract. They chased her on it. They didn't get her to sign it, as hard as they tried, she never signed it. Now, that was clearly their intention for her to have signed that contract. It was a key element to executing the contract. She didn't sign it. So at the end of the day, if you're in a situation where you have a contract that is not signed, then what you can say is, look, Wayfarer wanted Lively to act in a film. Fine, she did it. Lively got paid for that. Fine, she got her end of the bargain. You want to start, having the benefit of all the other little provisions of this agreement? No, you don't get that. You sign the contract if you want it to be fully enforceable. That is my position on contracts. Because if you turned that situation on its head, Lively could have, and Wayfarer wanted to sue Lively for something, enforce a provision in the contract, Lively would have just turned around and I guarantee you she would have said, well, I didn't sign it, so you can't, it's not binding. I guarantee you that she would have had the counter argument. So you want to be bound by a contract, you sign it. And that's it. And, if it's standard in Hollywood to not be signing these things in the entertainment industry, then, the entertainment industry needs to be more humbled and needs to, change. But in record time, we have Wayfarer's reply memorandum to Lively's opposition. It is not a long document, but let's go through it. I haven't read it yet. Okay, because I'm curious to know how they tackle Lively's arguments. Okay, defendant's argument for dismissal of Lively's FIA claim is only novel because Lively's attempt to extend California employment law beyond its natural metes and bounds is unprecedented. Lively cites no case in which a FIHA retaliation claim has proceeded, where the underlying harassment claim lacked a sufficient California nexus. In Lively's view, an employee or independent contractor has a retaliation claim under FIHA, provided the retaliation has a California nexus, and the plaintiff has an objectively reasonable but incorrect belief that California law might apply to the harassment claim. This would turn California law into a nationwide employment law policeman for companies with California headquarters and operations in other states. Exactly, that's what I said in my video this morning. That's just, it's ridiculous. This would turn California law into a nationwide employment law policeman for companies with California headquarters and operations in other states, reaching into other jurisdictions and forbidding any adverse treatment of employees who complain about conduct that may be perfectly legal in those states. Yes. That's a good argument. The plain language of the statute shows why this is wrong. Only practices forbidden under FIHA can give rise to a FIHA retaliation claim. So what they're saying is Lively's claims for sexual harassment did not meet the bar. That's why Judge Lyman threw them out. So nothing has been forbidden in that sense. And the same, at the end of the day, because it's irrelevant whether her claim was baseless or not, it did not meet the legal threshold to continue. So it was dismissed. So therefore, Wayfarer saying, well, okay, so it didn't hit the required bar of being, practices forbidden. The alleged sexual harassment in New Jersey with no California nexus is not a practice forbidden under FIHA, as when an employee complains about a type of discrimination not actually prescribed by FIHA, no amount of good faith on the part of the complaining employee can turn this into an objectively reasonable belief that California law was violated. Exactly. And that's a key critical point here is, there was no violation of California law in terms of the sexual harassment. So ergo, it doesn't matter whether she had a reasonable basis for, complaining. She cannot claim retaliation under FIHA. That's Wayfarer's position. The court need not, however, rule as a categorical matter. Lively's allegations are plainly insufficient to support an objectively good faith belief that California law applied to her harassment claims. Nor can Lively show that she suffered retaliation because of her filing a CRD complaint in the last days of 2024. Lively's FIHA retaliation claim should be dismissed, or at a minimum should be restricted to retaliation that occurred after the filing of Lively's CRD complaint. That's actually a fair compromise. That's a reasonable compromise. Okay, so let's get to the arguments. First one is the alleged sexual harassment in New Jersey with no California nexus is not a practice forbidden by FIHA and cannot support a FIHA retaliation claim. Lively cites no case in which a plaintiff has advanced a FIHA retaliation claim where the underlying allegations of sexual harassment have zero nexus to California. She therefore is asking this court to recognize something new. Liability for California-based adverse actions taken against an employee who has complained about conduct that have an insufficient connection to California is not forbidden under FIHA. Under Lively's expansive view of California law, a California-based HR department would be prohibited from taking adverse action against an employee at a store in New Jersey who complained about conduct proscribed by FIHA, but not actionable in New Jersey. The statutory requirement that a retaliation claim be premised on a practice forbidden under FEHA bars such a nonsensical claim. To get around this statutory bar, Lively must contort the text beyond recognition. Lively argues that practice forbidden under FEHA does not actually mean a practice forbidden under FEHA, but rather a practice of the same type as a practice forbidden under FEHA. I love this. Stated differently, the practices forbidden under this part language is meant to define the types of conduct and not the types of legal violations that a person may safely report. In other words, Lively argues that sexual harassment is a type of conduct prohibited by FEHA, and so sexual harassment occurring in New Jersey, as to which an employee can articulate some basis for a belief that FEHA might apply, will support a FEHA retaliation claim, provided that retaliation is sufficiently connected to California. This is not the law. The statute says practices forbidden under FEHA, not practices of the same type as practices forbidden under FEHA, and definitely not practices in other states that would be forbidden under FEHA if they occurred in California. As Lively acknowledges, quoting this court, quoting Miller, a retaliation claim will only lie if the practice the employee has opposed falls within the general purview of the statute. Sexual harassment in New Jersey with no nexus to California is not within the general purview of FEHA, and it is not conduct made unlawful by the Act. Lively says that the clear limitation in the statutory text will chill employees from complaining about sexual harassment, and that such concerns are heightened with respect to extraterritoriality. Not so. Title VII applies nationwide and prohibits both sexual harassment and retaliation against those who complain about sexual harassment. Similar laws are in effect in every state. Those laws, not FEHA, prevent an employer from retaliating against an employee who complains in good faith about perceived harassment. Lively's alleged good faith belief that defendants violated FEHA was not objectively reasonable. So this is the second argument now. Even assuming an employee's objectively reasonable good faith belief that harassment in New Jersey without a sufficient California nexus may, in some circumstances, support a FEHA retaliation claim, Lively has not come forward with facts to show she had such an objectively reasonable belief. Yeah, that's a really good point. Lively's arguments on this point do not move the needle. Lively suggests that the application of California's presumption against extraterritoriality to FEHA is unsettled, and that this renders her alleged good faith belief that she was covered by the statute more reasonable. This is nonsense. An objectively reasonable belief must be measured against existing substantive law. Campbell was decided 30 years ago. It has been widely followed by other courts, and Lively points to no case going the other way. As this court put it, Lively offers no reason for the court to depart from this consensus, and the court sees none. Lively also relies on the fact that the deal was negotiated by her California-based agent, manager, and entertainment lawyer. Yeah, this annoyed me. This was such a fucking ridiculous argument. It took me back to the second complaint with where she tried to get Jed Wallace back in, with her. Well, I posted that, on my Instagram that I lived in New York. So, there's my tie. Or they went to the premiere. So there's my tie. It's like, what are you fucking talking about, woman? And thankfully it didn't work. So hopefully this won't work either. Okay, so yeah, I'm going to just say again. Lively also relies on the fact that the deal was negotiated by her California-based agent, manager, and entertainment lawyer. None of this has anything to do with her harassment claim. Oh, she'll say the CRA did have something to do with her harassment claim, but yeah, I think Lively was actually talking about the ALA, which was unenforceable, but she was pointing to the California choice of law provision, and Wayfarer right, that had nothing to do with her harassment claim. Unsurprisingly, the court previously rejected Lively's contention that the alleged harassment had a California nexus due to the fact that Lively's counsel and representatives negotiated her employment relationship while in California. Lively also relies on the fact that the script anticipated filming in Los Angeles and that at the end of the shoot there were a few days of filming in Los Angeles. Lively does not allege that anything problematic occurred during those days. Indeed, the alleged harassment occurred more than 6 months previously, and Lively described the experience on the set following the return to work in January 2024 as highly professional. Lively also relies on Wayfarer's alleged failure to hire additional HR personnel or share HR policies. Lively made the same argument in opposition for the prior motion for judgment on the pleadings. The court described this as a formulaic recitation that cannot provide a sufficient factual nexus to California. So they're pointing out Lively's rehashing some of the same arguments that she used on the original motion for judgment on the pleadings, which the court has already rejected. Lively also relies on her conversation with Ange Giannetti, complaining about the alleged harassing incidents during the initial phase of shooting in New Jersey. The court flatly rejected this same argument, explaining that the fact that non-party Giannetti of Sony may have failed to act on complaints from Slate and Lively while in California cannot support a claim for harassment against the Wayfarer parties under California law. Finally, Lively relies on the continually negotiated ALA from which Lively repeatedly withheld her signature. Yes, she did. The court had little difficulty finding the ALA unenforceable for want of mutual intent to be bound. And they actually quote Lyman here. It is clear that the ALA is not and has never been a validly formed and binding contract. And Lyman pointed out, it ends with this movie on multiple occasions sought Lively's signature on the ALA. Lively on multiple occasions withheld it. Those requests and that withholding were not meaningless. They evidenced the parties' shared understanding that the execution of the ALA carried with it legal consequences. And then another quote, noting that by Lively's own estimate, 20% of the contractual provisions were not agreed, and that the specific provisions at issue are not insignificant or immaterial to issues of contract formation. And then we have a third argument. Defendants did not retaliate against Lively for filing the CRD complaint. Lively tries to rescue at least a part of her FIHA claim by noting that the filing of her CRD complaint is protected activity that would support a FIHA retaliation claim. Lively does not explain how anything defendants did following the filing of the CRD complaint, which she provided pre-filing to the New York Times, and Lively's lawsuit was anything other than reasonable defensive measures. Yes, very fair. Regardless, even if this small part of Lively's FIHA claim is permitted to go forward, which it should not be, the FIHA claim must be limited to the defendant's actions after the filing of the CRD complaint. Additionally, Lively's pleadings do not allege that after the filing of the CRD complaint, TAG did anything to substantially assist or encourage Lively's employer to violate FIA. Great. Do you know what? I'm really happy that they've made that kind of additional side argument for TAG specifically, because that's important. Because as much as Lively has criticised Wayfarer for their kind of impermissible kind of group pleadings, which is what they ended up getting sanctioned for, Lively is quite happy to do the same thing herself. And she is speaking about all of the current defendants, that would be Ainsworth's Movie, Wayfarer, and TAG, as if they all did the same thing. And she's not separating out to say what TAG did. So I'm happy that like Wayfarer sort of saying, hey, do you know what, if Judge Lyman is prepared to say, right, okay, I will grant, I'm gonna deny this motion for judgment on the pleadings, but I will accept Wayfarer's sort of suggestion to limit it from the time the CRD was filed. Then from then on, what did TAG do? So I'm kind of glad, because Wayfarer sort of taking a little shot here where they may not get out of it if Lyman says no, but they're making a good argument here to say, look, if nothing else, there's no kind of pleading for TAG here to say what TAG actually did. So really pleased to see that. Moreover, to the extent that TAG engaged in any activity after the filing of the CRD complaint, it was non-actionable, reasonable defensive measures. Accordingly, Lively's attempt to salvage her FIA claims with conduct post-dating the filing of the CRD complaint fails with respect to TAG. Conclusion: for the foregoing reasons, Lively's FIA retaliation claim should be dismissed, or at a minimum should be restricted to retaliation that occurred after the filing of Lively's CRD complaint. In all events, Lively's claim for aiding and abetting retaliation under FIHA should be dismissed against TAG. That was brought to us by Jonathan Bach. I really liked that, actually. It was funny. Very funny. And it was very well written, very well argued. I know we're all feeling a bit kind of miserable about the denial of TAG's renewed motion for summary judgment. I think there's a bit of a consensus against us lawyers that, we think Lyman has misapplied the law. Like when I first read that filing, I was like, okay, I can see why he is saying it. That's not the same as, is he saying the right thing? And now I've looked further, because like at the time the video was a reaction video, and now I've looked further into it. I feel like he's expanded law where it shouldn't be expanded. I think there's a bit of a consensus. I know Cassidy's done a video. I haven't watched it yet, but I will. But her mind's had a lot of thoughts, and she's not at all happy. I know Little Girl Attorney has also done a video on this as well, and she is the California employment law attorney, so she would probably have be in the best position to kind of weigh in on this. But she thinks that Lyman is expanding law. And I know Nag was I know not actually Golden, she did a video, and she did try to explain it and did a really nice job too. But also had to concede that she was confused, because it was not the result we were all expecting. I'm more optimistic with this. I think this is a good argument, and I've seen Lyman kind of say, absolutely not, for the same arguments. I mean, half of the Lively's arguments she's already been told no. But she's thrown them in anyway, because at this point she's got nothing to lose. So I'm more optimistic with this. But if this is granted, that just leaves the breach of contract claim for the CRA. So we'll see what Lyman said. Hopefully we will get a decision on this really quickly. Yeah, I can't see him hanging around now because we got a hearing, the pre-trial hearing on Tuesday, and a few more deadlines with some motions, especially surrounding the whole sealing and everything. But we'll see what Lyman says, and then from tomorrow my time, because it's already 1 o'clock in the morning now, but when I get up in the morning, I will start the process of going through the oppositions to the Daubert motions. So have a good evening, guys. Let me know what you think about this filing. I think it's awesome, but I'd love to hear some of your thoughts.